Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
This week on the Outlaw Lawyer, Joe and I answer your questions. We've got a whole show, just listener questions, ranging from estate administration to real estate to homeowners associations. We run the gamut. Listener questions all show.
And now,
the Supreme Court has said
unanimously,
this was wrong.
Fact-based.
Your belief at the time doesn't necessarily jive with what the actual law is.
Reasonable.
Informative.
Now, if you take in facts and you think about them and you don't jump to an
instant opinion,
you're the outlaw.
And now, Outlaw Lawyer with Josh Whitaker.
You're locked into the Outlaw Lawyers, Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm, practicing attorneys here in North Carolina, offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. I'm Morgan Patrick, consumer advocate. We talk legal topics each and every week, and it's question and answer on the program today. If you've got some questions legally that you're dealing with and you need some answers, I've got a phone number for you. 800-659-1186. That's 800-659-1186. You can also email your questions to questions@theoutlawlawyer.com. Just leave your contact information, briefly what the call or email is about, and an attorney with Whitaker and Hamer will be in touch. And as always, check out the website. It's a great one, theoutlawlawyer.com. Gentlemen, welcome in. Hope you had a great week.
Morgan, so far so good. Can't complain. I'm getting tired, as an NC State fan. We keep getting all this bad news.
Did something happen? I don't understand.
We lost a couple of kids via the transfer portal, and we're getting all this bad news. And then on the other side, all I hear about is this dang Final Four game is driving me nuts.
The other two programs in the Triangle, ACC programs, I should say, they're going to be dancing, but it's never happened before. North Carolina and Duke meeting. It's hard to believe, but meeting in the NCAA for the very first time, and it just happens to be for a ticket to the national title game. So, stakes are high.
It's terrible. It's literally terrible, man.
You going to enjoy that game, Joseph?
No, I think
no one's going to enjoy this game.
Exactly. I think both fan bases are going to agonize, and then the losing fan base, man, I tell you, that's going to be tough.
Yeah, it's going to be. If you're a neutral fan, like if you don't care, then you're going to enjoy the game. If you grew up especially if you grew up in North Carolina as a Duke or Carolina fan, and you're like a true, scream at the TV, get irrationally angry at the result of games type of fan, you're gonna be miserable throughout the game unless it's clearly decided in one either direction, and one team jumps out to an insurmountable lead. It's gonna be agony, man. It's gonna be misery. It's terrible. That's all I got. I think a lot of fans dreaded the possibility of this happening, and now it's happening. And something like this shouldn't have any effect on anyone's life, but for whatever reason, man, it stresses you out as a fan.
Yeah, everybody's like, just enjoy it. No, it's gonna be tough.
No, you can't enjoy it.
I was really rooting hard for Miami. I had all my eggs in the Miami basket. That's who I was going to root for no matter what.
Great year. That's a good team. Good team.
Well,
it's terrible, man. That's all I got. It's really bad. And, you always, if you put together a bracket at the beginning of the year, you're a Duke of Carolina fan, you kind of see the potentiality for this to occur. And, we've come close a couple of times. 91 was the last time that it was really a possibility. They were both in the Final Four. Too young to really remember that. But it's bad, man. It's really, really bad, and it's gonna be one of those things where I don't know that if you're a big fan of either team that you'll get much. You're just gonna be stressed out during the game, but it's gonna be a really, really fantastic feeling for one side, and it's gonna be an absolutely horrible feeling for the other side. And I tell you what, man, it's. You can say the pressure's not on either side or it not more so on either side, and that's debatable. You can give reasons for why there's more pressure on one team or the other. But, Carolina fans in particular, they've really clung to the fact that they beat, Coach K in his final home game, and they were sending him out on like a 1-game losing streak. And that was the last time they played each other, and that would be the lasting memory. And I tell you, man, if Duke beats Carolina in the Final Four, that's irrelevant. Like, no one's going to care about that ever again because it's trumped.
But if it goes the other way,
it's terrible. It's doubly terrible. You're right.
You're ending, the most historic, most successful coaching career in history. You're handing them an L in a national semifinal, and you're on your way to the national title game.
It's really bad. Well, it's really bad. And I don't know. It's going to take an emotional toll on both teams to where you got to think it's going to be difficult for whoever wins the game to pick it back up and perform well in that national championship game.
I wish there was a way everybody could lose. I wish there could just be two losers, maybe some sort of forfeit situation.
Look, Josh, as a big Duke fan, if you told me right now we could guarantee that Carolina would also lose, I'd take a Duke loss. If we could just disqualify both of them. Carolina losing means that much to me.
In the end, we just need to kind of take a big, deep breath and say, you know what? It's just a basketball game.
I'm not going to watch it. WrestleMania is on Saturday, so I'm going all in on WrestleMania. I'm going to pretend like it's not even on TV.
Dude, it's a train wreck. Man, I'm watching it. It's a train wreck. I'm watching it.
You've really... The things that bring you joy, Josh, I just don't get it, man. I just don't. You've really changed a lot, and since your days of being my rec league basketball coach. Your love of the game has really taken a hit.
I can't do it, man. College basketball and the state of NC State basketball, those kids played hard. I don't want to be a complainer, but you just can't. You can't, as a true state fan, you cannot garner. There's no bright side from anything that's happening right now. Like, you just have to pretend.
Man.
College basketball doesn't even exist.
As a true state fan, a true to life state fan, I think your hatred of Carolina should win out over your hatred of Duke, and you should be pulling for Duke in this game.
Well, I'm not rooting. Yeah, I can't root. I can't physically root for Carolina in this situation, but I don't. A Duke win is only slightly better. It's slightly more. I don't know. We watched the Wolfpack women. We watched the Wolfpack women games here in the tournament.
What a game! What a game!
That UConn game was a big game. Those girls played hard, and that was my boys were all into it. Like, we were all in on Wolfpack women, so we had a lot of fun watching women's basketball. But that's about all the joy we got from basketball.
Because I spent some time with your kids watching the Duke Michigan State NCAA tournament game. They had a great time watching that game, and I saw it in their eyes. I saw the hope in their eyes that they don't generally get when they watch a college basketball game.
Well, it's like, my kids, I think I mentioned on the show before, I'm born and raised here in Raleigh. I married into a family of Western New Yorkers, and so we watch the Bills in our house. And the boys were at a very impressionable age the past couple of years, and the Panthers have just, died out. And so the Bills have won them over. So I've got 3 lifelong Bills fans who will only marginally care about Carolina, the Carolina Panthers. And so I'm worried that's going to happen to state basketball. It's hard to make. It's hard to make these kids.
Myself, man, I literally saw. I could see the transition. Your oldest boy, man. I could see him wanting. He wanted something better for his life.
You can't make that kid root for state. I mean, we got football, so we got football coming up. We had to, we got our season tickets to football. We got to make a decision on state basketball tickets this week, and that I kind of think I made that. I think I made that decision yesterday. So, but anyway, I'm glad other people in the Triangle have things they can enjoy and watch.
State fan, no one's going to enjoy. If you're in the Triangle and you're a true fan of either team, no one's going to enjoy watching the game, Josh. The result will be enjoyable for one side or the other, but the actual physical process of watching the game for a true fan is going to be painful.
I think the only way a State fan could come out a winner in this is if Carolina and State play like a crazy record-breaking 10 overtime game. Duke barely wins, vanquishes Carolina. But Duke is so exhausted, they're like run over and massacred in the championship game. I think that's the only way the State fans could even remotely.
Are there 2 other teams in the Final Four? No one's talking about it.
Well, they're going to get the benefit of playing an emotionally drained team potentially. But I maintain, and this is going to sound crazy, national championship game doesn't matter remotely as much to either of these teams after this game. Whichever team wins this game.
Oh yeah, this is much more important. Yeah.
Well, it is and it isn't. You hear both coaches that's what they're stressing is we're here to win a championship. I get that, but for fan base purposes, like it's going to make losing a national championship much more palatable to whoever wins this game.
Well, I hope it goes horribly somehow, and I'll be watching WrestleMania, and I'll check in on Twitter and see what's happening. If it gets close, maybe I'll flip over, but otherwise, I'm going to pretend like it's just WrestleMania. That's it. I don't watch award shows. Did you guys watch the Oscars? You see all that happen?
I got to be totally honest with you guys. I thought it was this upcoming week, and I totally missed the Sunday night thing because we were watching, I was watching golf and doing other things, and I totally forgot about it.
I didn't watch it. I wouldn't watch it if I knew it was on. I didn't know it was on, but I still wouldn't have watched it if I knew it was on. But as soon as I saw social media blowing up with reports of what happened, I didn't watch the actual show, but I watched like every clip imaginable and really dissected it like as if it was some huge like conspiracy thing. Very, very, it got me to pay attention.
Well, that's good. That's good. I don't know much about it besides, what I've seen on social media. I haven't really dug deep into it. I know some people think it was fake. Some people think it was real. Chris Rock's going to be in town in April. I think he's going to be over at DPAC. It's something
We
I want to
ask him. Talk to him about it.
Yeah.
Get him on the show.
That might be I wonder how that show's going to go now with all this controversy, but it's got to be staged. Really?
I initially thought staged. Like my initial reaction was staged, and then I watched like 700 clips of it different ways, and I don't. Man,
because if it's not staged, then
what's the angle? What do you? I mean, you could say no press is bad, but any press is good press. But what? I just don't see the angle. Well,
they have strict rules about conduct, and the Academy may take the Oscar away. I know they're
that, but they let him get it, and then he gets the standing of. I just don't see them doing that now because what's the point now of doing it? He's accepted it.
And the following year he has to present, or will he? I mean, they say they're going to take a couple of weeks to make some kind of decision, but it certainly. It rocked everybody's world, especially social media.
Man, it's insane. It was insane, utter insanity. Assuming it was real, just complete insanity.
Well, I'd like to see Chris Rock file assault charges. That's what I'd like to see.
He did. He declined to initially. So, it was insanity, man. Like I said, it was. If nothing else, it made me at least pay attention to that aspect of it, and it was very interesting to say the least. Very interesting. A lot of memes too came from this. A lot of very funny memes. So that was that was a good development.
I think that's how I knew it happened. I think I saw a couple of memes. I'm like, "What's this madness?"
And that's the thing. That's the way we get a lot of our news about popular culture these days. Is you'll see like 700 memes, and you'll have to go look into so you can understand what's actually being made fun of.
Will Smith just did a big interview on CBS Sunday Morning, Morgan, a couple of weeks back. I didn't watch it though. I skipped ahead. It was boring me.
Well, up until this incident, Will Smith, arguably one of the most popular actors on the planet. People just like him. He's a likable guy. He's kind of on that same level as a Tom Hanks. He's done so many memorable movies. So this was kind of a shock to everybody that's a fan of Will Smith. It's going to be interesting to just watch the fallout. I know he's apologized. He was very tearful. He and his wife have had, their issues, and there's talk that they've got somewhat of an open relationship, and he felt like Chris Rock overstepped with the joke, but it certainly looked like early on Will Smith was enjoying the joke.
And his apology, that's another issue I had with it. He's since issued more of a formal written apology that kind of read like it came from his publicist. But if you watch like his acceptance speech and you hear him after the fact, he really wasn't apologetic. He kind of defended it. And, he tried to say you do crazy things for love, things like that. And it's just to me personally, it was a bad look. for Will Smith. I mean, you're a public figure. Yeah. You go to an award show, you sit in the front row, you understand what's coming. You're gonna get roasted essentially, and you never want to make light of an illness. And I don't know that Chris Rock was even aware that Will Smith's wife had the alopecia and had the issues with that. But at the same time, man, we can't as a society condone open hand face slapping a performer.
Maybe we should. Maybe that's a big
in
change.
That manner.
We should make a big shift in that. That's acceptable now under certain circumstances. But anyway.
Folks, the Outlaw Lawyers, Josh Whitaker and Joe Hamer, we are going to get into listener questions. That's coming up. Looking forward to this. Again, you can get in touch with Whitaker and Hamer. If you've got any legal situation you're dealing with, I've got a phone number for you, 800-659-1186. Again, 800-659-1186. Leave your name, contact information, briefly what the call is about, and an attorney with Whitaker and Hamer will be in touch. You can also email your questions to the show. That's questions@theoutlawlawyer.com. We'll use them on future programs. And just a reminder, Josh and Joe are practicing attorneys here in North Carolina and the managing partners at Whitaker and Hamer Law Firm. Offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay Varina, and Gastonia. We're back right after this.
Breaking up is hard, but your divorce doesn't have to be. Navigating the family law court system can be tricky. Let Whitaker and Hamer, PLLC, handle your divorce for you. Our experienced attorneys will listen to your story with compassion and understanding and will be there to explain the family law process every step of the way. Providing you with a clear understanding of the legal process while advocating for you is our top priority, so you can spend your energy focusing on your family. Give us a call at 800-659-1186. Again, that's 800-659-1186. Or visit our website, wh.lawyer, to set up your consultation with our team.
You're locked into the Outlaw Lawyers. Your hosts are Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm, practicing attorneys here in North Carolina. Offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay Varina, and Gastonia. I'm Morgan Patrick, consumer advocate. We get into legal topics each and every week, and you've probably got questions of your own. If you want to get in touch with the firm, get some answers, number to call, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the show, questions@theoutlawlawyer.com. Guys, we've got questions. I love this part of the show, so let's get into it.
Well, Morgan, we got a couple of questions. The first one I want to tackle here at the firm, here at Whitaker and Hamer, we do a lot of estate planning for clients, and we do a lot of estate administration. So that's kind of two sides of the same coin. So we help people get their wills squared away, power of attorneys, kind of plan where their assets are going to go, trust, things like that. That's all estate planning. And then estate administration is once that client, we don't want any of our clients to pass away, but once that client passes away, a lot of times we'll handle the estate administration. So we take that plan they put in place for their assets when they passed away, and then we help execute that plan when that day comes. And so the first question we have this week is kind of an estate planning question, and I've kind of rephrased it. I always paraphrase these things to take out names and things like that. But here's how I'm going to phrase this question. So we've got a listener who said, I am remarried. I have kids with my first spouse. How do I make sure my kids and stepkids are all treated equally when I die? So in this fact pattern, attorneys always make things fact patterns. In this fact pattern, we have a client. I'm going to make him a guy. He was married. He had some kids. That didn't work out. It sounds like he's divorced, and he is remarried, and has we'll have stepkids. So he's got his new wife has some kids, and so they all live together. And so he's taking care of He's got an ex-spouse. He doesn't give us a number, but we'll say he's got two kids from a prior marriage, and then he's got his two stepkids. And I'm going to make another assumption in this fact pattern. We're using the term stepkids, stepchildren. So he hasn't adopted. These aren't his kids. He's not the father of these children, He's helping to take care of them. We're also going to assume he has not adopted these children. So these children are not his. The law is very clear on who your heirs are. If you don't do something, if you don't plan accordingly. And so, Joe, this is that blended. We call this a blended family estate plan, and these can be tricky.
They can be tricky, Josh. And you said one thing that really stuck with me early on when you were setting this up, and that's we don't want our clients to die. I think we can all agree. I think we can all agree that that's the case. That should be the tagline for our firm.
Right.
We just roll out advertising. Whitaker and Hamer. We don't want you to die. But yeah, this is a tricky situation, Josh, and you said it. We've got what we would call, I guess, your biological blood children that you that were born of the first marriage. They are the kids, and then you get the remarriage, you get the stepkids, and this individual in this fact pattern could very much love these stepkids and treat the kids like they are his own children. But the amount of love he has in his heart for them and the way that he treats them, and no matter what he does, there's going to be a legal barrier in the event that he passes away, in the absence of some careful strategic estate planning.
Yeah, and that's the thing. I guess that's the situation to look at. So if he doesn't do anything, right? So if this gentleman, a valued listener and potential client of Whitaker Hamer, if he does nothing and passes away, and everyone survives him, so we'll make some more assumptions in our fact pattern here. So we always have to kill these guys off to make our fact pattern work. So something happens to him. The laws of North Carolina, it's called intestate succession. Since he does not have a will, has not put an estate plan together, the laws of intestate succession are going to determine where his assets go after his death. And so here, I'm going to say he has 2 kids from a previous marriage, and he's got a current spouse, and that's who's going to inherit everything, right? The current spouse is going to technically inherit a decent chunk of his assets. The law is always wants to protect the widow, and of course his children will inherit percentages. So these are all percentages. These aren't specific assets. 2 kids and a wife, they're going to split everything, thirds, right? So if you have a house, everybody gets a third, right? That's not always easy to hand out to people, and so that's kind of the default. And in the default, these stepkids, stepchildren would not receive anything, no matter how our deceased husband felt about them or cared for them. They're not his children, and the law is very, very clear about what happens in this case. So if he doesn't do anything, his stepkids will not receive anything in this situation. And so that's kind of the default. And so to prevent that, he would go to an attorney and he would set up an estate plan. And Joe, in that case, what do you think what would your advice to him be? Assuming he wants to take care of the stepchildren just like his own.
And that's it. That's the thing. The drawback to failing to have any kind of an estate plan in place, or having, an outdated estate plan that doesn't account for your current circumstances, because this guy could have an estate plan in place, but it could be, it's likely that's going to be something. Well, it's not likely. It's a certainty. If he's prepared an estate plan during the time that he was initially married, he's not going to have made any kind of arrangements for these stepkids that he doesn't even know are going to exist in the future. So, and you mentioned the fact that you can't have those specific, what we call specific bequests to individuals when, in the absence of a well-crafted estate plan, in the absence of a will stating otherwise. The statutes that dictate how your assets are going to be distributed, it's going to be very generalized. It's going to be percentages. And you just lose every aspect of control after your death if you fail to account for it. You don't put that into writing in the proper way. So, my recommendation, there's a lot of recommendations as far as you can keep it very, very simple, or you can make it far more complicated. But just as a very simple recommendation, the like baseline, what I would recommend is draft, either revise or draft an all new estate plan that accounts for these stepkids. And, whether you craft a will that's going to leave them a percentage or some specific items that you would like them to have, or whether you wanted to create a trust that's going to establish a trustee that's going to, operate for the benefit of those stepkids, you need to have some kind of concrete and tangible estate plan that's going to account for those stepkids. Otherwise, they're going to take nothing.
And I'm kind of taking this a step further than our question. In our fact pattern, we've killed off our loyal listener here, and we're looking at how his assets would be divvied up under the law. And then, of course, if you make a will, things are going to get divvied up however you want within reason. There's some things you can't do, but if you draft a will, and you can do everything, you can do anything you want to. You can say, hey, I've taken care of my spouse, and she has assets in her name. I want all the kids to split certain things, or I want stuff to go in a trust. I want to make sure their school's paid for, and your estate plan is wide open if you sit down with an attorney and you draft the relevant documents that you need to make your plan happen. If you don't do that and you die without that in place, then the state has a 7-page statute, and that statute is going to determine where things go, and there's not anything you can do about it once you're gone. But Joe, I would point out, we're killing off our listener. He's got a surviving spouse. Usually when we talk about estate plans, we usually craft it so that your surviving spouse doesn't really have to do anything, right? So you're creating this will saying, I want all my kids and my stepkids to share and share alike. But if we've done your estate plan properly, there's not really anything in your estate. So your will is kind of a catch-all. And so you may have to think about other ways to provide for your children, life insurance policies, setting up a trust that has real property in it, or some asset you want to make sure goes to them. Sometimes we have to create assets so that when you pass away, there are things in place for your kids. Since your surviving spouse, usually you'll share some bank accounts. Your residence may be you and your current spouse, and so that'll just automatically go to your spouse. So there's a lot of things. Just when you die by operation of law, if you've set it up, your spouse is just going to keep on moving, right? So you may not even have a lot of estate assets if you're the first spouse to pass away. And so there's always some thought, like I said, life insurance or trust or something to create while you're alive that'll make sure your kids are taken care of when you pass away. So just something to keep in mind on that blended family discussion.
We've got a lot of questions to go, guys, so we're going to get to it. You're listening to the Outlaw Lawyers, Josh Whitaker and Joe Hamer. You can find them at Whitaker and Hamer Law Firm. They're the managing partners there. They are practicing attorneys here in North Carolina. If you've got a legal situation you're facing, you've got questions, it can be about really anything, you can call this number, 800-659-1186. That's 800-659-1186, and just leave, a brief message, what it's about, contact information, and an attorney with Whitaker and Hamer will return your call. You can also email your questions to the show, questions@theoutlawlawyer.com. We're going to take a short break. We're back with more questions from our listeners right after this.
Get your Outlaw Lawyer fix any day of the week.
Now, if you take in facts and you think about them and you don't jump to an
Instant opinion.
you're the outlaw.
The Outlaw Lawyer Podcast with Josh Whitaker.
The Supreme Court has said
Unanimously.
this was wrong.
Available on Apple, Google, Spotify, or wherever you listen to great podcasts.
And now,
Outlaw Lawyer.
Welcome back into the Outlaw Lawyers, Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm. They're the managing partners there. Offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, and Gastonia. And again, the fellas, practicing attorneys here in the great state of North Carolina. If you've got a legal question of your own, you can get an answer. Here's a number for you, 800-659-1186. That's 800-659-1186. Leave your name, contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. You can always email your questions to the show, and we'll answer them on the air on future programs. Questions@theoutlawlawyer.com. What's up next, fellas?
Well, Morgan, the next question I have we get this question in a lot of different ways. That's what I wanted to say. It comes up in different ways. The paraphrased version of the question I'm going to use for today is basically, what is the difference between a healthcare power of attorney and a power of attorney? And the answer is there in the name, but this still causes a lot of confusion for folks. Joe, what's the difference?
The answer is right there in the name, Josh. That's a very simplified way to put it. But there's a few key differences, and there's a few different ways that these two things operate. And the way that I'd encourage you to look at it, just for the purpose of simplifying what could be a more complex answer, is you've got the healthcare power of attorney, and you've got what we would call just more of a general power of attorney. And that general power of attorney is going to be used more for day-to-day type of activities, cutting checks, making decisions, things that aren't, it's tough to just use, like you said, the exact wording of the two types of POAs, but things that aren't healthcare related decisions. These are more just general day-to-day type of operations and decisions, whether they involve money or assets or whatever they may be, conducting your day-to-day business. That's what that general power of attorney is going to apply to. The healthcare power of attorney, just like the name implies, is going to be more specific to healthcare related matters. It's going to apply where it's a concern of an individual's health, and generally speaking, that's going to be something that's going to take effect in the event of an individual's incapacity. When that person is incapacitated and can't make those decisions themselves, that is when that healthcare power of attorney is going to become extremely valuable. Because if you've got a situation where something happens to you, you aren't in your right mind, you can't communicate what you want to happen with yourself, you could have a person that's got a general power of attorney. And if that general power of attorney doesn't specifically address the healthcare related matters that are at issue, you're going to be out of luck. And that power of attorney is going to be essentially worthless for that purpose.
Yeah, two very different documents. They're both given life by different statutes in the North Carolina general statutes. And so, like Joe said, the healthcare power of attorney is something everybody should have. It's become real popular over the past decade or so, especially with kids who turn 18 and are going off to college and still probably rely on their parents for help and maybe calling the doctor and doing whatever needs to be done medically, get medical records, things like that. And so most everybody who's an adult should have a healthcare power of attorney. It's a very easy form. It's not overly complicated. It speaks to maybe some forms of life-ending treatment you may or may not want. But basically, you're appointing someone for your doctor to ask questions to. If you're unconscious, you've been in an accident, or you're not of sound mind and you can't make your own medical or healthcare decisions, the doctor needs that in his file so he can ask. I would argue even a spouse, or if you want a child, or if you want multiple people. I usually don't recommend that in my consults, but anyway, that's who your treating physician is going to look to in a medical emergency where you can't make your own medical decision. So it's handy to have. And then Joe, like you said, the general power of attorney is more complex. That's one that obviously you can give somebody, a child, a friend, a family member, a professional, your CPA or your attorney or whoever. You can make someone your attorney. In fact, they can act on your behalf to take care of daily business, a specific piece of real property. It can be drafted as general, deal with everything, or as a singular, as again, just dealing with, I'm going to be out of the country. I need you to take care of selling 123 Fake Street. 123 Fake Street. You know where that came from?
No, Josh.
I'm going to guess a Simpson episode.
It did come from The Simpsons. They, if you go back, there's an episode where Bart, I don't remember, this was the B plot. I don't remember what the A plot was, but Bart is strolling through like a courthouse and they're having an auction and no one's bidding. So he bids $1. And it's this old warehouse that's falling down. And it's 123 Fake Street. But anyway, they could take care of just this. Bart could appoint, and I think he does pretty much. I think he puts Milhouse in charge, and Milhouse ends up wrecking the factory. It all falls down. It's very comical.
So in this situation, Millhouse is the attorney in fact for Bart, legally speaking.
That's right. Yeah, I had that. I had a law. I'm not going to say his name. I'm not going to put him out there, but I had a law professor. Law professors, this is what we do in law school. They give us fact patterns, and we take case law and statutes, and we try to analyze these fact patterns. And sometimes they're fact patterns from cases, right? Really famous cases. And sometimes they make up names, and then sometimes you have the law professor who just takes cartoon characters and just puts those in your very serious legal fact patterns you're trying to analyze. And I have a feeling if I was a law professor, that's probably the way I'd go. It'd be a lot of Simpsons characters' names in our fact patterns. But anywho, power of attorney is very serious. Powers of attorney, very serious. Lots of trust there, right? Because if you're giving someone the power to do something on your behalf, they can do it, and people can rely on it, and they're protected. It creates a fiduciary relationship, so that person has very strict legal duties to do what's best for you. Power of attorneys can take effect immediately, right? So as soon as you sign it, it can be set up to be effective. And that person can go do whatever you've authorized them to do on your behalf. Or it can take effect later. So you can go ahead and sign it, but in the body of the document, we can say, hey, this won't take effect until a doctor decides I'm not competent to handle my own affairs, right? So you can have one that won't spring into existence until a doctor says, hey, Josh is done, right? Josh can't make his decisions anymore. This person is going to be their POA. And so when you're doing the estate plan, that's the hardest part for some people, right? When I'm doing an estate plan with folks, one of the hardest things for them to do is figure out, okay, who's going to be the guardian of my minor children if something happens to both me and my spouse, right? That's one of the hardest questions people have, is deciding on who that should be. The second hardest thing is deciding who should act as my attorney. In fact, it's usually going to be a spouse, and then if something happens to that spouse, you got to name a number two, and so that's hard for folks. It's hard to, especially as people get older, it's very hard for them to turn over that kind of decision making to someone else. No matter how much trust is there, it's just it's not always easy.
It's tough, man, and like you said, a lot of trust is required. And that's why I think we as attorneys, we would encourage, very careful drafting of these documents and making sure that you're specifying, each and everything you want these individuals to be able to handle. Because, you mentioned the fact that a general power of attorney is a very complex document. That can be true. And I think a well-drafted general power of attorney is something that's very complex. But you've also got what's called a statutory short form general POA, which is just literally, it's defined by statute. It just lists out the things, and you go in and you initial beside it. So they can always, they can be fairly straightforward as well. And you can just give blanket authority to somebody to do pretty much anything as far as that POA goes. And I think I would encourage, and we would encourage our clients to carefully consider exactly what authority they're giving out. And again, that trust piece is essential. So have people you trust.
It does make a difference. And we've been at this for a while now. So I have seen people abuse these, right? So I've seen the people who appoint their kids or, someone attorney in fact, and, that attorney in fact tries to make self-give gifts, make deals that benefit them more than the person they're acting for, basically violating these fiduciary duties that exist. And so that definitely happens. And so it does necessitate some thought. And usually people have that one person, right? People like, hey, if something happens to me, I want Josh to make those decisions. He'll do what is in my best interest. And they feel real good about that. And then we start talking about, well, do you want to name a backup? Do you want to name, if Josh passes away, do you want to have someone else there? And they're like, that's usually tough, But anyway, lots to think about. Very important documents, very central pieces to any estate plan, but take some thought.
Question and answer continue with the Outlaw Lawyers, Josh Whitaker and Joe Hamer. Stay tuned. You can find them at Whitaker and Hamer Law Firm. If you're going through a legal situation and you've got questions, we've got a phone number for you, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. You can always email your questions to the show, and we'll use them in upcoming programs. Questions at theoutlawlawyer.com. We're back with more questions and answers right after this.
Want to hear more Outlaw Lawyer? Catch up with the newest episodes and more by visiting outlawlawyer.com and subscribing to the podcast on Apple, Google, or wherever you like to listen to great content.
The Outlaw Lawyers, your hosts, Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm, offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, and Gastonia. They are practicing attorneys here in North Carolina. If you've got a legal situation you're facing, we have a phone number for you, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the program, questions@theoutlawlawyer.com. We'll answer those on future programs. Always check out the website. Great one for you, great resource, theoutlawlawyer.com. Gentlemen, take it away.
So our next question, I get this, Morgan, I get this question a couple of different ways. Some people really like their homeowners association, right? The HOA. Some people really like their HOA and what it does for, keeping certain standards up in a community, protecting resale values, whatever you think homeowners associations do that's good. There's people out there that like them. And then there's people out there that avoid them like the plague, right? They don't want to buy anything that's subject to covenants that creates an HOA. And so we see both sides of that come through our office. But I've had a couple times, and this listener question, I've kind of added this in here, this situation I see. But basically, this question is going to start out: I didn't know I had an HOA when I bought my house. So basically, these folks bought a house. They were not informed by the sellers that there was a homeowners association, and so they've closed. Their closing attorney failed them. That should have probably come up at closing, and the sellers certainly failed them. But we won't get into that. They're in a house. They didn't know they had an HOA. They do. The HOA is saying, I owe HOA dues, and are threatening to file a lien. Can the HOA do that? And so the short answer is yes, right? You don't have to have personal notice, right? When, we do a lot of real estate closings at Whitaker and Hamer. Joe and I spend a lot of time dealing with real estate closings and litigation. And basically, when a developer starts a neighborhood, a subdivision, they'll record covenants, protective covenants. And most of the times, and in our day and age, those covenants will authorize or, call for an HOA to be set up. And that HOA can have further rules and things that it does. But so you can, these folks, it's unfortunate, especially if they're trying to dodge an HOA, but they've got one, and they owe dues. As long as the dues comport to the covenants and the rules of the subdivision, they can be levied. And if you refuse to pay them, the HOA's got a few things they can do to you. Joe, I don't know if you've seen this one before.
Yeah, I've seen it. It's not super common to see this. You do see it, but just as a general principle, it's important to understand your notice of any kind of real estate title related issue, defect. It's going to have very little effect on the fact that issue is going to be a problem for you, because these are things that are there. And so you can't use as a defense to non-payment of HOA dues the fact that you didn't understand or realize that there was an HOA, because if you could, most likely that's what everyone would say, right? I didn't know there was an HOA. I'm not going to pay you any money. And it's really irrelevant, because it's a public record issue, and this is something that's on record. So using that is not going to be any kind of a defense. And I think it's also, just as, again, a general principle, if you're buying a house and you're buying a house in a subdivision, I think you just assume that you've got an HOA. I mean, I think that needs to be your assumption. Now, that's not always the case. There are exceptions to that. You've got some, there's a threshold of homes where if you've got a smaller subdivision, you may not be required to have an HOA. You could have a larger subdivision where everyone's kind of come together after the fact and decided, we don't really want to have a formal HOA or have HOA dues. So there are exceptions to that, but I think it's just just as a general assumption, you just assume you're going to have HOA dues and you seek out that information and understand, what's going to be due from you. But another thing that kind of plays into this is the fact that you're coming to an attorney to handle your closing. And it's going to be hard to be surprised by this because your attorney is going to be doing their due diligence and they're going to be pulling that information. And, 99.9% of the time is if you got an HOA, there's going to be some money that's going to be due from you at closing. There's going to be some information that has to be provided to that HOA. So you're going to see these things on the closing disclosure when you come to the closing table. So you really should not necessarily be surprised by this. But, assuming that you are surprised by this, HOAs do exist. HOA dues also exist. And if you don't pay those dues, you can absolutely have a lien filed on you. These are all things, that's authority that's given to these HOAs just by virtue of law. And you can't avoid it by just saying, hey, man, I didn't realize this was a thing.
Yeah, notice in the real estate world is not personal notice, right? It's notice, at the register of deeds or the clerk's office or recorded registered documents at the courthouse. That's how you get constructive notice of these things. And if you're one of those people that really want to avoid an HOA, when you talk to your real estate agent, when you're looking, you need to be very vocal about that, so hopefully you don't even look at anything that has an HOA, assuming the sellers have been forthright and, that kind of thing. And then you need to let your closing attorney know. So closing attorneys, when we do searches, we'll find HOAs, we'll find covenants. But we need to know if that's something you object to, we need to have a conversation. And the closing timeline is always pretty short, right? We're always, 2 to 4, 3 to 5 weeks away from closing once you go under contract. And so things move pretty fast. So that's something you need to let everybody know, right? Because that's something you need to be upfront with. But an HOA can definitely file a lien, right? And they'll file a lien, and that lien will sit there, and that'll be something that has to get paid off if you sell the house or you refinance. And there's all kinds of ways that can affect you negatively. And then at some point, if there's enough owed, the HOA could decide to foreclose on you. That's one of their remedies at law is say, hey, you owe us $5,000 in dues and fines and attorney's fees and all kinds of stuff, and we're going to foreclose and sell your house at auction, right? And so that's kind of their that's the big stick that a HOA holds, because they can foreclose on you and sell the house, and of course whoever buys it at auction would own it, subject to if you have a first mortgage or an equity line or whatever, that's still there and that's still in your name, but you no longer own your house. And so HOA can do a lot of stuff, good and bad, depending on how you view them. But for this question, I would pay those dues, lickety split, and make sure you were on good footing with your HOA, because they got some ways to make your life a little more complicated, I guess is the easiest way to say it.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, the area growing in such fashion that there are going to be a lot of neighborhoods and there are going to be a lot of HOAs. So if you've got any questions about your situation, we've got a phone number for you, 800-659-1186. That's 800-659-1186. And just leave your contact information, briefly what the call's about. An attorney with Whitaker and Hamer will be in touch. You can always email your questions to the program, questions@theoutlawlawyer.com, and we will feature those questions in an upcoming show. We've got a few more questions for you. That's coming up on the other side. Stay tuned for more The Outlaw Lawyers.
COVID-19 turned all of our worlds upside down and forced us to question whether or not our loved ones would be provided for after we're gone. It's good to be prepared for the future, but drafting a will can be tricky on your own. A will determines what happens to your property after your death. Your last wishes need to be properly detailed, so don't leave that task to just anybody. At Whitaker and Hamer Law Firm, their inclusive will packages include healthcare power of attorney. That's to cover you during accidents and other situations where you may not be able to make the call on medical procedures. Let their firm give you peace of mind and help you prepare for whatever your future holds. Give them a call at 800-659-1186. Again, that's 800-659-1186. Or visit the website wh.lawyer.
Welcome back into the Outlaw Lawyers. You have Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm, your hosts of the program. Each and every week we get into legalese. They are practicing attorneys here in North Carolina. They have offices conveniently located in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. If you're facing a legal situation and you've got questions, we've got a phone number for you, 800-659-1186. That's 800-659-1186. You can leave your contact information, briefly what the call's about. An attorney with Whitaker and Hamer will be in touch. And as always, email your questions to the program. We'll use them on future shows. We'll answer them for you. Questions at theoutlawlawyer.com. Guys, we got time for at least one more question. Where are we going?
So our next question, I get this a lot, and so we've kind of paraphrased it to include the most common situations we see. But in this listener question, we've got we were selling family land. So we're seeing that a lot right now. We talked about that, how everything is kind of kicking up a notch in the real estate market, and almost anything that can be on the market here in Wake and Johnston and Harnett and surrounding counties is getting sold. So these folks are decided it's time to sell the family farm, the family land. So they went out and sold it. Somebody agreed to buy it, and now there's a closing attorney involved, and the closing attorney won't close this because we didn't open a estate for my grandfather. What now? And so, Joseph, I know you see this one a lot.
We do see it. I was actually just talking to a client about basically this exact issue the other day. So it's a thing, man. It's a potentially common thing. And, when you talk about, a grandfather, a great grandfather, you talk about an older generation, we always stress very careful estate planning, avoiding probate, avoiding these exact type of issues. But you get a lot of folks who are a little more old school in their approach, and these might not have been things that they necessarily took care of. They may have not cared at all, like as in this situation where there was just never an estate opened. And so as to the what now, it really depends. It depends on the exact situation. It depends on how your grandfather owned title. It depends on who their heirs are, and you can get into some pretty complex situations just based on family structure, number of children that were had, where those kids are at this point. We as attorneys, we're going to search title, we're going to find as much as we can, and when we get into a situation where there's an issue like this on the seller side, it can frustrate our buyers a lot of times, but we represent the buyer. We're conducting the title search on behalf of that buyer, and we can't really assist with seller-based estate issues. So what we're going to likely tell the seller to do is to go and hire independent counsel, hire an attorney to assist you with resolving this issue, and kind of put the burden back on that seller. And that upsets a lot of people, but it's basically the way we have to approach it due to bar rules in general.
Yeah, when we represent a buyer and we do that title search, that's all we got, right? So if you're selling the family farm that's been in the family for years and years and years, we have to do a certain search. We got one right now, and we're back in the 1860s because it was family land, and there's not a lot of deeds, right? Normally if I decide I want to buy something from Joe, we'd have a closing, I'd have a deed recorded, and there'd be evidence that I bought this property, and I'd have my deed. And so when you inherit property, the only way a third party, a buyer, a closing attorney, someone else looking at it would know that you bought it is if an estate had been opened. Because if in this situation, the grandfather, when he passed, if an estate had been open, it would list all the heirs, what shares, 1/8, 1/16, 1/32, whatever share they got of the land. The estate itself acts kind of like a deed. It's a public record that this man has passed, where he lived, and who his heirs were, and we can work with that. But when you take that out, we don't know your family history, right? We don't know that, you had an uncle who died early and his two nephews, one is illegitimate, one's legitimate. And we can't figure it out without this estate. And so there's some workarounds, but, I think the long and short of it is this person has a problem that's going to take an attorney or multiple attorneys to figure out. And so, you always hear real estate as a non-probate asset. I think that confuses a lot of people. But even though it may not pass through an estate, the estate is a good record of who it did pass to. And then if you don't do it, then people die. It gets inherited again. Like we got one now where, one of the uncles didn't have an estate and his kid died, doesn't have an estate. So we're like 4 generations down now with no public record of who the owner is. So definitely something that takes an attorney spending some time with it.
Exactly. It's gonna take some time. And I think the important thing for, if you're in this situation, there's a few things that you need to keep in mind and a few things you need to do. Step one is you need to get on resolving the issue as quickly as possible. So the sooner you can, retain an attorney or start doing the legwork on getting that estate filed, the sooner you're going to be able to resolve it and get to the closing table. But that being said, these things, they can take time, and they generally do take time. So you don't need to expect this to be a quick or easy fix. You need to plan on it taking a decent amount of time. You need to, you or your real estate agent needs to set the buyer's expectations that, this is an issue that's going to take a little while to resolve. And depending on what your contract says, you could be in a situation where you're going to end up basically either being in breach or having to seek some kind of termination of that contract yourself, or you're going to be in a situation where the buyer is going to give you some leniency. You may come to an agreement to get an extension on the amount of time, but you need to plan on it taking a decent amount of time. And just the quicker you can jump on it, the quicker you can get it resolved. But it is going to be a thing that it's going to take some time.
Well, speaking of time, guys, we're out of it. The Outlaw Lawyers, this edition in the books. Guys, have a great week, and we'll see you on the radio next week. This is Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm, practicing attorneys here in North Carolina, the managing partners at the firm, offices in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. And if you've got a legal question that you have, you can get an answer. 800-659-1186. That's 800-659-1186. Leave your contact information, briefly, what the call's about, and an attorney with Whitaker and Hamer will be in touch. And as always, you can email the questions to the show, questions@theoutlawlawyer.com. We'll answer them on a future broadcast. We're back on the radio next week.
Outlaw Lawyer is hosted by an attorney licensed to practice law in North Carolina. Some of the guests appearing on the show may be licensed North Carolina attorneys. Discussion of this show is meant to be general in nature, and in no way should the discussion be interpreted as legal advice. Legal advice can only be rendered once an attorney, licensed in the state in which you live, had the opportunity to discuss the facts of your case with you. The attorneys appearing on the show are speaking in generalities about the law in North Carolina and how these laws affect the average North Carolinian. If you have any questions about the content of the show, contact us directly.
Get your Outlaw Lawyer fix any day of the week.
Now, if you take in facts and you think about them and you don't jump to an
Instant opinion.
you're the outlaw.
The Outlaw Lawyer podcast with Josh Whitaker.
The Supreme Court has said
Unanimously.
this was wrong.
Available on Apple, Google, Spotify, or wherever you listen to great podcasts.
Coach P Radio.